We'll call this meeting to order. As indicated, my name is Michael McHenry. I am the hearing officer. It's my duty to conduct this hearing today based on the petitions that have been filed. I'm required to look at your application based on the evidence as presented at this hearing and also the applicable standards which will be passed out to you at the beginning of the hearing. Based on the evidence, I will either recommend approval, modified approval, or denial. There will be a record made of this hearing, and after the transcript has been prepared, I will prepare and file my recommendation and report the following week. The county board is the one that will make the final determination. My opinion is only a recommendation. If I find approval for your request, then all you need is a simple majority of the members of the county board who are present to vote in favor of it. If I deny your request, you then need a 3/4 majority vote of the county board members who are in attendance. We are trying to make a record today, and I am somewhat deaf, so I ask you to keep your voice up, Mr. Hellier. And if you are asked a question, do not give a shake of the head or a hump. You must answer audibly, yes or no, and you will be treated with respect today, so I would ask that you follow that same rule and treat everyone here with respect. And you are Mr. Zagarski?
David Schmitz.
I think I pulled the wrong one. You're right. You're Mr. Schmidt, correct?
Yes.
And what are you hoping to do today?
I'm asking for a variance to allow a house to be built on this property.
And what variations are you looking for?
So it's A1 zoning, which requires a minimum of 330 feet of frontage, and I'm asking that to be reduced to 126. And asking the lot size to be reduced from a minimum of 40 acres to 0.95 acres.
Okay. And for the record, that is a request, that is a correct request. The petitioner is seeking a variation in the A1 agricultural district to allow a minimum lot frontage of 126 feet instead of the minimum 330 feet required, and also a minimum lot area of 0.95 acres instead of the minimum 40 acres required. The subject property consists of 0.96 acres, is located on the north side of Area Street, approximately 230 feet east of the intersection of Little Drive and Area Street. The common street address is 804 Area Street, McHenry, Illinois, Township of Nunda. The tax ID number is 1529376004. And the adjacent land use would be single-family residential to the north, east, and west, and to the south would be vacant. The current zoning would be A1 agricultural. The adjacent zoning would be A1 agricultural to the north, south, east, and R1 single-family residential to the west. The property is designated residential by the McHenry County Land Use Plan. Municipal plans within 1.5 miles would be Cary, no designation, Oakwood Hills and Prairie Grove, and Point Barrington, no designation, Island Lake, existing land uses. The property is currently vacant. There are no wetlands, there is no floodplain, and there are no historic floods of record. There is, however, an area of a elevated aquifer contamination. And when did you buy the property?
2006.
And was it vacant at that time?
Yes, it was.
And at that time, did you think that the property was buildable?
Yes, I did.
Did you have any reason to believe that it was not buildable?
No.
When you looked at your property, how did it compare to the adjoining properties?
The exact same size as the adjoining properties, at least everything on that street except for the one immediately to the west that was slightly smaller, already had a house on it, but everything else is the exact same size.
So all the other properties in the nearby area, with the exception of one, were basically the same size lot, and they had a house already existing?
They already had houses on them.
And those houses, were they also in McHenry County, or were they in any municipality?
They are in McHenry County.
And you indicated that your one neighbor, used to be a township supervisor, is that correct?
Yes, from Nunda Township.
And who was that person?
Lee Jennings?
And did you talk to him when you were acquiring this property?
Yes, I did.
And what did he tell you?
He didn't give me any advice about the actual buildability of the property. He just said it was a nice piece of property, just like his. He'd love to have a house there and have a neighbor there.
Okay. And did he give you any information that indicated that you couldn't build a house on that property?
No, he did not.
And did you post the requisite sign that you were supposed to post on the property?
Yes, I did.
And have you later learned anything about the history of the property?
I learned a little bit as I've gone through this process to request the variation.
And was there ever a house constructed on the property?
Yes, there was.
And when was that?
Apparently it was built in 1935. It was not there when I bought the property, and I learned from the neighbor it had burned down years before I bought the property.
Okay. But that house did exist on the property for a number of years, did it not?
Yes, it did.
And at the time that house was constructed, according to your information and belief, that was constructed with the applicable zoning rules that were in time.
As far as I know, yes.
And what are you hoping to do with the property?
I am currently selling the property to someone who hopes to build a house on it.
And is your contract for sale contingent upon the successful rezoning of the property?
Yes, it is.
Have you talked to any of your neighbors regarding your request?
Not specifically about this change in request, no.
But after you put up the signage indicating that you were going to make this request, did any of your neighbors talk to you and give you any indication that they were opposed to your request?
No. Like I said, as far as I know, the one neighbor is in favor of it, and I haven't talked to the others.
And I gave you a copy of the standards. You have those in front
Yes,
of
I
you?
did.
If we go through those, you are a math teacher, correct?
Yes.
It makes you pretty much the smartest man in the room, doesn't it?
I don't know about that.
Well, I'll concede to that. I mean, I concede that I'm not smarter than Mr. Hellier, but I'll concede that you might be smarter than I. Isn't it true that the particular surrounding shape or topographical condition of the specific property involved would result in a particular hardship upon you, the owner, as distinguished from a mere inconvenience if the strict letter of the regulations were carried out? Isn't that true? I'm sort of suggesting, isn't it true?
Yes.
Good answer. Isn't it also true that the conditions upon which the application for a variation are based are unique to the property for which the variation is sought and are not generally applicable to other property within the same zoning district? Isn't that true?
Yes, it is.
Good answer. Isn't it also true that the purpose of the variation is not based exclusively upon a desire to increase the monetary gain realized from the property? Isn't that true?
Yes.
And isn't it also true that the alleged difficulty or hardship is caused by the ordinance and has not been created by any person presently having an interest in the property? Isn't that true?
Yes.
Isn't it also true that the granting of the variation will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located? Isn't that true?
Yes.
Isn't it also true that the proposed variation will not impair an adequate supply of light and air to adjacent property, or substantially increase the congestion in the public streets, or increase the danger of fire, or endanger the public safety, or substantially diminish or impair property values within the adjacent neighborhood? Isn't that true?
Yes.
Isn't it also true that the granting of the variation requested will not confer on you, the applicant, any special privilege that is denied by this ordinance to other land or structure of the same zoning district? Isn't that true?
Yes.
So if a neighbor had a similar situation and they made a request to get it rezoned with the variation that you're requesting to build a house, you would be in agreement with that, correct?
Yes.
And this property originally had a house on it, and that predated the current zoning rules, correct?
Yes.
So the difficulty that you're confronted with is really a change in the rules on the property compared to what had been in effect when the property originally was subdivided or the house was built in 1930.
Yes.
If the 1930 house was still in existence, you wouldn't need the request you're making today, would you?
Correct.
Kim, do you have any questions, comments?
I don't have any questions. Just again reiterating that this is kind of an unusual situation where all of these residences were built by my research between the 1920s and the 1990s down that street, all on the same lots, same use that is being proposed. So it's a little bit interesting that a subdivision was never created or recorded, but this is consistent with everything else down that street there. So.
Are all of the nearby lots the same dimension, the same size?
Exactly the same.
And they're all rectangular?
Correct.
So it makes it look like somebody had attempted to plat a subdivision?
Yes.
And are all the other lots also zoned A1?
Yes, they are. Except for the property to the west, that is R1.
And in terms of the 1930 house, was that properly permitted?
The zoning ordinance and building permitting wasn't a thing then, but it was, according to the assessor, the township assessor said that it was constructed in 1935 and burned down in 1999. So as far as we know, that was a legal structure.
Why do these lots not have like an R zoning on them?
They have the original agricultural zoning. Nobody ever came in to rezone them, and so they just kept their original zoning. I can't explain how all of those residences were built on A1 zoning, other than the fact that our office does more research now as into the buildability when someone comes in with a permit.
Were some of the nearby homes on the A1 lots constructed in the last 10 years, 15 years?
The last house that was constructed down there was in 2003, that I could find.
Okay, and they didn't have to come in for a variation?
They did not.
Is there a reason we're picking on this poor gentleman?
As I mentioned, we are just more diligent now in our research on the buildability. Back 20 years ago, apparently they were not.
And it doesn't appear that we have anybody here who is responding to this particular petition. Based on the evidence that's been presented and the unusual circumstances, I would be in favor of the request. I would recommend approval to the county board. When would be the next?
That will be on April 18th.
You do not have to be there at that meeting. You certainly can go if you want to. The odds are that you will be on what's called the consent agenda, so they will simply pass a number of items in a more simplified manner. But you can check with the staff the day after to verify what the vote has been. I would find that he also has met the standards that are requisite to this particular petition. You, sir, are free to go and celebrate Pi Day.
All right, well, thank you very much for your time.
Thanks for coming
And
here on Pi Day.
thank you, too.
Pi Day has a different meaning for most of us.
Well, my kids, it's both kinds. They have,
And you heard me do the introduction, correct? Again, I would ask you to keep your voices up. And for the record, this would be the petition 2021-002, Adam and Anne Marie Zagarsky as trustees of the Zagarsky Family Trust, owners of record. And the request would be a variation within the R1 single-family residential district to allow for a setback of 0.85 feet from the south property line instead of the minimum 10 feet required for a detached garage, and also a height of 19.5 feet instead of the maximum 18 feet allowed for a detached garage. The property consists of approximately 1.18 acres and is located on the east side of Woodrow Avenue, adjacent to a channel of Pistaki Lake with a common address of 4818 Woodrow Avenue, McHenry, Illinois, in the township of McHenry. The tax ID numbers would be 1008, 176, 002, and 003, and also 004. The current land use would be single-family residential and vacant, and the adjacent land use would be vacant Pistachey Lake Channel to the north, single-family residential to the south, east Pistachey Lake, west vacant. The property is currently zoned R1 single-family residential. The adjacent zoning would be R1 single-family residential and Pistachey Lake Channel to the north. To the east, Pistachey Lake, south R1 single-family residential. To the west, R1 and R1C single-family residential. The 2030 plan does designate this to be environmentally sensitive, and the municipal plans within 1.5 miles would be Johnsburg, medium-density residential, Spring Grove, no designation. The property is currently improved with a one-story frame residence, frame garage, lean-to shed, concrete gravel driveways, fencing, other areas of concrete. There are no wetlands on the property, and there does appear to be some reference to the 100-year floodplain, and the historical flood of record is mapped for the entirety of the subject property. It is in an area that has a sensitive aquifer recharge area, and it appears that there was a building permit that was applied for. Mr. Hellier, can you tell us what you're hoping to do today?
If we're permitted, we're hoping to seek a variance of the side yard setback to the south. Normally, in the zoning district, it would require a 10-foot setback. The garage is, with the lean-to, is closer than that, and we would be asking for variance of that 10-foot to a 0.85 feet setback, and for the south property line. And with respect to the height of the garage, where normally the maximum is an 18-foot, we'd be asking for a variance to 19.1 feet, based again on the unique nature of the lot and the topography.
Can you explain why the building was built to the 19.5 and not the 18?
Part of the problem is with respect to the, as you mentioned in your introduction, the topographic nature of the lot and the proximity to the water, both in front and the side. It cannot, the homeowner can't use the entire parcel of property. They can't just place it where they want if you're too close to the water. With respect to the height, it's my understanding that the floor of the garage was raised up because of the aquifer and the groundwater issue. And again, that's a separate issue that we have to address with respect to stormwater. But everything was kind of just raised up, and again, I think there was, it was done to accommodate the groundwater, and it ended up being a foot and a half higher than that was permitted under code.
Sometimes people put additional elevation of a garage so that they can use the upper portion for some kind of storage or for an office or whatever. Is there any inclination to do that with this particular property?
And stuff like that up there, like rafts and stuff, you know.
Are you going to put up any flooring?
You know, we have 3 kids, and our intention, currently living in the city of Chicago, is to want to get out of there. Crime has gotten really, really bad. 2 I already have in high school, 1 going to high school, and my whole idea was just get out of there, move to this current lot. And I think we got a little ahead of ourselves, too excited and trying to hurry up, right to finish it up, and weren't quite privy to exactly how things were done. Had I known what I know now, we certainly would have gone a different route and done it exactly how the county wanted it to. But it's already done, so we're trying to fix it according to however they will allow us to do that.
And your property is on Woodrow Avenue, is that correct?
Yes, sir.
And if you're facing Woodrow Avenue, it dead ends to the left, does it not?
You're facing it, I think.
If you're facing Woodrow Avenue,
Yeah,
to the left is a dead end.
yes,
And the properties, I guess it would be to the south of your property. Are there homes on those properties or are they vacant?
the one at the end of my house, which is to the left, does have a home and a garage on it. I think their garage is a little bit closer to Woodrow than mine. The other side, which is a channel, there's nothing there. There was a small garage, that was it.
So you have very minimal traffic on Woodrow Avenue.
Almost
Heading
none unless
south.
you live there, yes.
Okay. So the fact that you're a little bit closer to the property line, that wouldn't impede any driver's ability to drive safely, would
No,
it?
sir.
And that's again because you have such minimal traffic.
Correct.
And you did apply for a building permit, is that correct?
Yes, I did.
Kim, can you explain the situation with the building permit?
Yeah, so a building permit was obtained for the detached garage. And then the addition to the south of that garage was put on after the fact. So the application is on file for that addition as well, but has not been issued until the variance and stormwater variances are obtained.
Okay, how do you determine that the shed is different than the garage that they applied for?
So the detached garage met the setbacks from the street side and from the south. And then I believe it was when our inspectors went out to the site, had indicated that this addition had been put on with the lower roof line there to the south.
So clearly the building permit application was simply for the detached garage.
Correct.
And at that point, no one had indicated that they would be putting on this shed.
Not that I was aware of.
Okay. But the garage itself met the required setback.
Correct.
So why does a shed not meet the required setback?
Because it is only 0.85 feet from the south property line. As you can see in that lower right photo there, you can kind of see where that overhang is from the lot line is pretty close to the neighboring property there. And a 10-foot setback would be required.
Okay. And you would agree that there is minimal traffic on this road?
Yes.
And what is staff's position regarding this request?
Being that the request does not seem to affect really any, traffic or sight lines, the neighbor that's most affected to the south has not indicated to us, at least, that they have any issue. We haven't heard from anybody. I don't believe we have any issues with the variance requests.
That's staff's way of saying they don't object and they can prove it. There's a limit to how far they will go with what they say.
They have their turn.
You're looking to go through the standards.
Yeah. May I proceed?
Sorry?
I said, may I proceed?
Absolutely, sir.
Isn't it true that the particular surrounding, shape, or topographical condition of the specific property involved would result in particular hardship upon the owner as distinguished from a mere inconvenience if the strict letter of the regulation was carried out?
Yes.
Isn't it true that the conditions upon which the application for a variation are based are unique to the property for which the variation is sought and are not generally applicable to other property within the same zoning district?
Yes.
Isn't it true that the purpose of the variation is not based exclusively upon a desire to increase the monetary gain realized from the property?
Yes.
Isn't it true that the alleged difficulty or hardship is caused by the ordinance and has not been created by any person presently having an interest in the property?
Yes.
Isn't it true that the granting of the variation will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located?
Yes.
Isn't it true that the proposed variation will not impair an adequate supply of light and air to the adjacent property or substantially increase the congestion in public streets, or increase the danger of fire, or endanger the public safety, or substantially diminish or impair property values within the adjacent neighborhood.
Yes.
And finally, isn't it also true that the granting of the variation request will not confer upon the applicant any special privilege that is denied by this ordinance to other land or structure of the same zoning district?
Yes.
Kim, the residence was constructed in 1928. Is that correct? It's in your report?
Then yes.
Okay. Have there, if you know, did they need a building permit back in 1928, or they just simply build?
Yeah, our office was not doing building permits back then, so.
Have there been any improvements to that structure since it was originally constructed in 28?
There was a removal of a detached garage. I'm not sure when the detached garage was originally constructed. And other than that, it was just the driveway and the structures in question that I'm aware of.
And there probably wasn't a whole lot of zoning rules in effect back in 1928, I'm assuming, is that correct?
Correct. Yeah.
So whoever built the house configured the lot however they chose to do so, and then they built the house, is that correct?
Correct.
So that person's decision back in 1928 is really what created kind of this odd-sized lot, correct?
Correct.
And even if we grant this request, they still have to go through storm water, is that correct?
Yes, that's correct.
Can you explain that, please?
My understanding is that due to the flood hazard on the property, the structure needed to be elevated a certain amount. Let me just double check. I have an email here from the Stormwater Division that kind of explained that. Yeah, it needed to be elevated a half foot above the base flood elevation. So they needed a variance, I believe, for it to be below that. Is that correct? Yes.
So if there were any potential concerns of any neighbors regarding any runoff, that would be addressed through stormwater, would it not?
Right.
Have you received any information from any neighbors either in favor of this or against this?
No.
And have you talked to any of your neighbors, and if so, what have they said?
The one directly to the, is it south of me? I'm friends with them. My kids play with their little kids, and they've not addressed any concerns with me. They were happy with the property and the improvements we made, and they even gave me a letter stating that they weren't questioning if we did what they liked.
And you did post the requisite notice that you were required to post for this hearing?
Yes, sir.
Anything else, Mr. Hellier? Today seems to be the day for somewhat unusual lots and situations. Again, we have an older piece of property that goes back to 1928 regarding the construction of the residence. I think the requisite standards have been met. I would be in favor of this and I would approve it. This will go to the same county board meeting.
Yes, April 18th.
And your attorney can explain to you what that means.
Yes, sir, thank you.
I appreciate it.
Good job,
Thank you, sir.
Mr.
I
Hellier.
appreciate it. Well,
90.